CTGraves, and I practice family law in the Washington, D.C. area. One of the questions we have to think about, like say if you're married and you're dealing with your house and you own it together, the question is, well, we have an asset that we need to deal with. Sunset, they just abandoned me and come back. They've been gone. They've been gone. They've been gone. They ain't seen nobody, so I guess it's over. Hello, I'm back. Okay, so today you guys know that I'm back. I've been gone for a while, so I've got to catch up, or I've missed you all, or maybe it hasn't been that long, but it feels like it's been a while. And there are a couple topics today that I wanted to go over. And the second topic for today are prenuptial agreements, because I'm getting a flurry of calls, and people are saying the information is not out there, that you guys that do prenuptial agreements are difficult to find. So I said, let me fix that. So if you didn't get it, I'm going to give it to you. CTGraves, family law and estate planning attorney in Maryland and Washington, D.C. area. And today's video is about prenuptial agreements. I'm getting a lot of calls. People are getting married, woo, celebrating marriage, but they're not just jumping in blindly. People want to know what's going on with prenups. Should I get one? Do I need one? How can it help me? So this video is going to be pretty short. And I'm going to go over high level what the prenuptial does. There's a lot of myths about it, probably. I think when I actually read one, I was a bit surprised. I think there's some things that I thought, and there are other things that I didn't know. So, and that was after I was an attorney. Okay, so I'm going to share this video with you and break down high level what the prenuptial is designed to do and how it can help you protect your assets. So if you're thinking about getting married and you've acquired some things and you're wondering whether a prenuptial agreement is for you, stay tuned. I'm going to give you some tips on to help you make a better decision and be more informed. And always that is the intent of my videos, is to put information out there so us as a community can be more enlightened, be more informed, more savvy, and be able to deal with life with a bit more information. We always don't have attorneys at our disposal. I know I didn't growing up, so I want to be involved in my community. Okay, so prenuptial agreements. Now, prenuptial agreements are estate planning documents. People tend to think that they're related to marriage, but marriage is the thing that triggers this estate planning document, okay? So we are in the realm of estate planning. And so if you're looking for a prenuptial agreement attorney, it's some family law attorneys do it, but you need to be looking more on the estate planning side. And I'm going to tell you why. So what happens is, I think you guys are kind of aware, or are very aware, that if you get a divorce, there are certain rules that the court will follow to distribute assets in your estate. Right? You guys kind of know if you get divorced, this is how it's going to go. There are a default set of rules. Okay? Right? Now, one thing you may not know is that there are also a default set of rules as it relates to your estate when you pass away. Those are the rules of intestacy. I just did a video 2 minutes ago relating to estranged spouses and how those rules of intestacy impact your estate. They're everything to the game. Just like those default rules, the state has come up with a plan on how to get you guys divorced, divide the assets. If you're going to pass away, who's going to get what? No one's waiting for you guys to plan, because most people don't. But the prenuptial agreement is your opportunity to say, well, maybe I don't want those default rules. Maybe I don't want to divide assets equally. Maybe I don't want all my kids to get my estate equally. Okay. Maybe I don't want to give my spouse half my money. Maybe I don't. Okay. This is where you get to make these decisions and change default rules. Prenuptial agreements change default rules. Okay. There are a set of rules in place. So thinking about it like that, let's talk a little bit about what those default rules are and how you can change it. So the key thing when it comes to marriage is that in a lot of states, Maryland, D.C. included, once you acquire property during the course of the marriage, despite whose name is on the asset, it's considered marital property. Okay, so acquiring assets, what does that mean? A lot of times I hear things like, well, I owned the townhouse before we got married. Well, did you own it or did you enter into an agreement with the bank to slowly acquire it over time, right? Through your mortgage payments to acquire the asset. You don't own it yet, you are in the process of owning it. You're in the process of acquiring it. Here's the thing that people tend to not know. In these jurisdictions where that is the default rule, the thing that makes it a marital asset is that you use some marital property to acquire it. Guess what's marital property that a lot of people tend not to believe is marital property? The money you earn at work. Even though your spouse didn't go to work with you, you guys are one economic unit now once you get married. So when that person goes to work, half of that check is your spouse's. And when you go to work, half of your check is, you know. So you and your spouse are going into the world as one economic unit, buying houses, cars, the cell phone, the stove, everything, right? That is the default under Maryland and DC law. So what can happen in an example? Let's take it on that you owned the townhouse before you got married, where you were in the process of acquiring it. So let's distinguish. Now, if you own it in the law, it means that you completely acquired free and clear title prior to getting married, not marital property, nothing to concern yourself with. Now, if you have title to this asset and have a mortgage and you start using your half of your spouse's money that you earn each day and get a paycheck for to pay down that asset, they start saying, half that property is mine because half the money used to pay for it is mine. That's how this is working. The prenuptial agreement says, oh, well, nah, I don't do that. Guess what? That asset, that townhouse that I started acquiring, that maybe I want to keep acquiring for whatever reasons, that's going to be my individual asset. The prenuptial agreement changes the default rules in a myriad of ways, which you guys get to design. It's pretty exciting and cool. But the basic change is, listen, I don't want to do it by default, acquire assets during the marriage. I want to do it intentionally, meaning that if it's not both of our names on the asset, I didn't intend for it to be a joint asset whose name on the asset rules. You can change it. So that's how the court will process and distribute your estate, your assets during a divorce. So let's back it up a bit. Remember, I said in the beginning, it's changing the default rules in separation, divorce, and when you ultimately pass away. Okay? So there's two sets of rules here that you get to augment, and divorce is the most prominent one that people think about. So that's why we're going to start there. So you're changing the default rules. There's things that it also deals with is the time period upon which you guys are separated. Because when you are separated, there are entitlements as a spouse. That's where, we call those pendente lite, uh, you know, wherefore clauses for relief. They're claims for relief. Pendente lite is Latin for pending litigation. So when you hear that word, just call it like, a temporary order until you get to the final, not to be fancy with the Latin, but technically that's the term. Okay, so there are entitlements that you can ask the court for, or your spouse can ask the court for. And that's like temporary alimony, right? And you can make a decision about that. Should we come to a point where we separate, I agree to pay, alimony in the amount of, and then there's a lot of creativity in what that might be. You could say pay your housing or give you $500, $1,000, or some triggering condition that we could use to calculate what that might be. A lot of people don't do that. A lot of people don't go that far, I can say, in the common use of a prenuptial agreement. But what they're typically using it for, the other big asset So we talked about the house, right? The other big asset is retirement and 401ks and TSP thrift savings accounts. For the average person, protecting your interest in real estate and protecting your interest in your TSP and 401k account, big stuff, big stuff, big stuff. I mean, definitely say again, because again, what happens is the money transforms, the income transforms into a marital asset once you get married. So again, as you're putting money aside in your TSP account, thrift savings account, 401k account, any investment account, uh, E-Trade account, Merrill Lynch account, I don't care which account, any account that you're putting that marital money in, that asset takes on a marital asset quality. Okay. And you may say, well, look, now I think I should be able to just, put my money aside and mind my business. And this can be an issue if one person is a spender and another person is a saver. So, this is another thing. One of the most common uses, and I think one of the most useful, common uses of a prenuptial agreement is to exclude assets from the default accumulation of marital interest. Okay? Putting that aside, saying, okay, look, babe, love you. Okay. I want us to make it to the end. I want us to go the distance. I didn't get married to get divorced, but please tell me that if something were to go astray, that you wouldn't want to clean out my retirement that I'm going to try and use to take care of me in my old age. Okay. Can you tell me that from the gate? I mean, is this love or is this money? Which one we doing right now? So I have always viewed prenuptial agreements as pretty much of a nice love letter. Like, babe, before if this doesn't work out and this gets ugly and mucky, I don't want all that. Let's just decide now while we love each other, if it don't work out and we gave it our best and we went to counseling, this is how we're going to resolve this because we don't ever want to fight about our marriage or loving each other or property or things like that. Okay, you write it in that spirit. You write it when things are good. You write it like, babe, no, I don't want, before you're vindictive and bitter and mean and mad, write it now. So that's the spirit of the prenuptial agreement. A lot of times I've done prenuptial agreements and reviewed them for couples, married into a lot of wealth, a lot of wealth. They say you can't come up in this wealthy family unless you sign off. And those, when they're that high level sort of prenuptial agreements, you're talking about tiers. People are, especially when you're talking about a distribution from a divorce or a marital asset award or something like that, they'll say if we make it 1 year, you get, 50,000, 2 years, you get 30, whatever, tear it on up to maybe if we were married, we made it 7 years. I give you 150 in a settlement, call it done. And if we make it all the way until I die, you get whatever you would naturally get, and this agreement is no longer. It's really for that premature termination and dissolution of the marriage. But if we make it to distance, babe, whatever I got is yours. Sweetest thing I've ever, I mean, I almost got choked up when I read it. I was like, oh, this is so sweet. Okay. So that's what you're dealing with on the divorce side. Now, let me tell you what it does not cover. It is not going to deal with your children. It's not, this is for alimony. This is for money and property. Prenuptial agreements are about money and property. They're not about your children. Okay. And they're not used as contracts to police your spouse's behavior. Okay. So you can't put clauses in there like we agree that you're going to, take out the trash, and the husband can't believe like you agree that we're going to be intimate 6 out of 7 days of the week. You can't put that stuff in there, y'all. Okay. That's not what it's for. It's for the easy distribution and dissolution of your marriage and dealing with money, property. Okay. So that's separation. That's divorce. Now, the prenuptial agreements can take care of this. All this next stage can stand alone. And I'm going to advise this one particularly for people who have businesses and business partners. Okay. One thing you do not want to do, one of the things you don't want to do is you don't really want to get into a partnership with a person without having them sign, having their spouses sign away their interest. You don't want to be in a business venture and now your business venture is under the audit of someone like me, because now half of all that money belongs to my client. And I want to see your books, I want to see your records. Come over, send it over, right? I need to add a value to this asset because we need to divide it up. And maybe you don't divide it up. Maybe your spouse becomes a partner in your business. Again, in this prenuptial, you could exclude the business. So that's another big asset that we're putting there. Like almost, I say, if you have a business, you almost absolutely, and it's not just your sole proprietor business or LLC, you really want to consider excluding your business. And if I were doing business with someone, I would almost, before I enter into a partnership or joint venture with anyone, I think, and they're married, I would ask them to sign, have their spouse sign a waiver or have some particular terms in your agreements, your operating agreements, as to how any interest subject to divorce and or your estate would be handled in the business. So contemplate that if you are in a joint venture with others. So those are big assets. So we are covered real estate in the prenuptial agreement as a big asset. We've talked about your thrift savings, your retirement asset accounts, which are usually people's biggest assets, that these two. And then of course, if you have a business, okay, these are things you want to think about, and you're going into a marriage after acquiring these assets. Now you say, well, dang it, I'm getting this video way too late. What if I already have the asset and already married, and maybe now you want to expand and add a partner? You can do what we call an antenuptial agreement, whereby your spouse can sign, and you guys can negotiate their value. It doesn't have to be zero. You know what I mean? Maybe you say, look, I don't want this to be a big deal. Can we agree on a number, 50,000? Probably based on, if it's a big asset, you're probably going to have some negotiations on what that waiver is, because it doesn't have to be zero. Someone could say, well, just give me 50,000 and I'm good and I won't ask for any more. You can negotiate a number, or they can say, look, I don't want your business, I got my own business. So you cross waivers, you waive yours, I waive mine, we're good. So you can do it like that as well. But these are things you have to think about, because having your business caught up in a divorce litigation, no bueno, no bueno. It's so expensive. Okay. It really adds, on the low end, $20,000 to the cost of your divorce. And you're like this, wow, divorce is going to cost $20,000? Yeah. And especially if you got a business that has assets and it's a real thriving business, yeah, it can be a big deal. So if you have a smaller business and it's just service provided, no, it wouldn't be that much. Now, so then we go down to the last stage that it covers, and that's dealing with the estate. Now, this one, I don't know. It's all up to you. It's how you design your estate. And I was thinking about this, but the thing about it is the prenuptial agreement has the ability again to augment the default rules of intestacy through the agreement. Where, like I said, so what happens? What's the default rules? You keep saying the default rules. You keep saying the default rules. So let me tell you what some of those default rules are. Okay. So here's what they sound like. Now, if you have a spouse and no living children, your spouse is going to inherit 100% of your estate. Just like if you have no spouse and you only have living children, they will inherit 100% of your estate. This prenuptial agreement relates particularly to your spouse. So if you don't have any kids and you don't want your spouse to inherit 100% of your estate, you're going to need to do a spousal waiver and or election, and deal with it in some form, shape, or fashion, because that's what's going to happen under the law. Those are for the assets that flow through your estate. Okay. So, what if you have a spouse and kids? And they're not minors. The law gets really particular about how old these kids are. So, your spouse will inherit the first $40,000 of your estate, intestate estate property, and half of the rest, and then your children get the rest. So they take 40,000 off the top, right? So say your estate is worth, I'm just trying to do this math real quick, y'all. Here we go. So say your estate is worth 100,000, and that means your spouse, your intestate estate is worth 100,000. Your spouse is going to get 40,000. Okay. Then that means there is 60,000 left. That 60,000 is going to be split amongst your spouse again and your heirs. Okay. So in this scenario, your spouse would get 40 plus 30. They would get $70,000 of this estate, and 30,000 would go to your kids. If that's okay, fine. If you want to change that a little bit, you're like, no, wait a minute. You might not want that, and it goes down. It keeps, but this is how detailed it is. You can actually calculate this. So I'm not going to go through all of them because it just keeps, you know going here. There's a distinction whether they're minor or not. If they're minor kids, they get more, of the estate versus kids that have reached the age of majority. So if your kids are not minors anymore, your spouse is going to get more of the estate. But if your children are still minors, they're going to balance it a bit more. Okay. So these are the things that these estate planning documents change. And you could easily, like, say if you didn't have a spouse, you could easily change, how much each kid gets, blah, 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 through your will, through your, revocable living trust. But the status that your spouse has is significant and unique, and it will require an intentional writing from your spouse. Now, there are really good reasons to do this, especially if this is like your second marriage and you already have grown kids. I would highly encourage that you have your spouse taken care of through an insurance policy. Get an insurance policy state in the house, because leaving a spouse behind to deal with stepchildren, unless they get along in some angelic, June Cleaver, Leave It to Beaver way, which typically is not the case, you really want this to protect your spouse so they're not dealing with any disputes, any bitterness, any vitriol, any jealousy, in addition to grieving your loss. So think about it. There's ways to have assets that don't flow through intestacy, and you hear me refer to them in terms of insurance policies. Any of the assets that ask for you to designate a beneficiary, anytime you're filling out a beneficiary form as it relates to a titled account, whether it's through the bank, whether it's through your employer, whether it's through your investment account, insurance policies, anytime you're naming a beneficiary, that is a contract. And those contracts augment the intestacy rules. And they say, we're not going through intestate. We have an agreement, insurance company and, insurer, we have an agreement on who's going to get this money. So I'm not going through intestacy. So know that you can really circumvent intestacy altogether. Putting assets in a revocable living trust in completely takes those assets out of intestacy, but they're not beyond the reach of calculating whether you've disinherited your spouse. So with all that being said, you want to consider the dynamics of your family. You want to do estate planning to ensure that you protect those hard-earned assets that you're toiling to diligently be responsible for in terms of building equity, saving for retirement, and things of that nature, or building future nest eggs for your children. You want to plan thoughtfully for your spouse. And I'm not of the mind where you just cut somebody out and you just say, "Oh, you're gonna get nothing." No, I don't. I wouldn't sign that. Okay, it just means that we need to think about a plan that benefits us both. That's thoughtful, right? And we use the tools available to think about our future. It's sitting down and thinking about the future honestly. It's big people work, putting on your big pants and sitting down and really thinking about how I can ensure the future for myself and my family, avoiding unnecessary costs of probate. It's expensive. So when you don't plan now, you pay later. You pay 5 times more later, honestly, in probate. So there's no reason not to do it. If you're thinking about getting married, congratulations. I'll leave you guys with this tip. Don't wait too long. One of the things that prenuptial agreements need is time for contemplation, negotiation, and consideration by both parties. You do not want to send out wedding invitations and then say, "Hey, I'm gonna need you to sign this paper." Sign the agreement, or "I'm gonna let everybody know the wedding's off." That's like duress. Okay, everybody knows we're getting married. What am I gonna do now? We set the wedding date. We paid the caterers. Everybody's coming. It's a destination wedding. We'll lose so much money on deposits, and then this person's coming up 3 months before the wedding talking about a prenuptial agreement. I just signed it. That wouldn't be worth the paper it was written on. Okay, so if you're thinking about it, the other person will need to have an opportunity to get their own lawyers to review it, to make sure they understand it. And that protects you to make sure that everyone could say, "I had an opportunity to investigate this, get some guidance about it, make a counter offer, negotiate it." It's not a fast process that you want rushed, because then it's vulnerable. It's Swiss cheese almost. Okay. So I hope this was helpful in regards to prenuptial agreements and you feel that you are a bit more informed about them. If you have additional questions, you guys can reach out to me. My information is noted below in the description, and I will tune in with you guys again with another video. And these shows come up from issues that I encounter in my practice on a daily basis. So I hope you guys are enjoying the summer and being safe, and I will chat with you again. Thanks so much for tuning in. I'm Carmise Graves, and I practice family law in the Washington, D.C. area. One of the questions we have to think about, like say if you're married and you're dealing with your house and you own it together, the question is, well, we have an asset that we need to deal with. Sunset, they just abandoned me and come back. They've been gone. They've been gone. They've been gone. They ain't seen nobody, so I guess it's over.